When you're buying a property in Florida, it's easy to get lost in the excitement of the location, the kitchen design, or your loan terms. But there's a legal decision often ignored that can determine the future of your estate, the well-being of your family, and how easy or difficult it will be to pass that property on to the next generation. Hi everyone, I'm Ricardo Teran, co-founder of Folio Title and your Title Sherpa. Today, we're talking about title vesting, or the way you legally hold ownership of your property. As your Title Sherpa, I'm going to guide you through this terrain so you can understand exactly what it is, why it matters, and which options you have in Florida in clear, simple language. Let's start with the basics. What is a title? It's the legal document that proves you own the land and the property. Having title gives you a bundle of rights. You can live there, rent it out, sell it, or pass it on to someone else. The official document that records this ownership in the public record is called the deed. Title vesting is simply how the names of the owners of the property appear on that deed and how ownership is shared if there is more than one owner. If it's just one owner, it's pretty simple. But what happens if you buy with a partner or a business associate or your spouse? Vesting defines who has control, what percentage each person owns, and most importantly, what happens if one of the owners passes away. When a property is purchased under a legal entity, such as an LLC or trust, title vesting works a little bit differently because ownership shifts from the individuals to the entity itself. The deed reflects the entity as the owner, while the entity's operating agreement, corporate documents, or trust documents determine who has the authority to act on the entity's behalf, including selling, transferring, or refinancing the property. So let's talk about some title vesting options when an individual owns the property. In Florida, we have several paths to choose from, but it's very important that before making a title vesting decision, to seek advice from an attorney if you need further interpretation of these title vesting differences. Let's break down the 5 most common types of title vesting. Number 1 is sole ownership. This is the simplest because one person owns 100% of the property and is ideal for single buyers or investors investing in their own name. The second form of title vesting is joint tenancy with right of survivorship. As the name suggests, there is a right of survivorship, meaning that if the owner passes away, their share automatically transfers to the surviving owners. For this to work, the deed should explicitly state the magic words, joint tenants with rights to survivorship. Number 3 is tenancy by the entirety. This is a special type of title vesting available exclusively to legally married couples. In Florida, marriage is treated as a single entity in a tenancy by the entirety. So this kind of title vesting includes an automatic right of survivorship, meaning if one of the spouses passes away, the other becomes the full owner without going through probate court. Instant peace of mind. A huge additional advantage in a tenancy by the entirety is a protection against individual creditors of one of the spouses in a homestead property. The magic words here on the deed will include the relationship between the spouses, such as husband and wife. Fourth is tenants in common. This is where 2 or more people own the property, but each has their own separate share. It could be 50-50 with 2 owners, or it could be any percentage distributed amongst any number of individual owners. What's very important to understand in a tenancy in common is that there is no automatic right of survivorship for the individual owners. If an owner dies, their share goes to their heirs according to the rules determining inheritance in Florida statutes and/or according to a person's will. This type of title vesting will usually require going through the probate process upon the death of one of the individual owners. This type of title vesting is common for friends and family purchasing a property together, though it's always important to seek advice from an attorney or CPA when purchasing an investment property to ensure the optimal way to hold title in each case. A 5th option is trust ownership. Think of a trust like a safe with a set of rules. The safe is the trust and it owns the house. The rules, which are in the trust document, say who has the key and what they can do with it. Trust ownership is a favorite for estate planning because it keeps your affairs private, may have significant tax advantages, and usually can avoid the probate process entirely. It's important that buyers who wish to buy in a trust consult a real estate or trust and estates attorney to review the multiple trust types and how they can impact their ownership rights and taxes. So now we know that title vesting affects who can sell or refinance, whether your property goes to probate court when an owner passes away, and a married couple's protection against lawsuits in their homestead property. But timing is everything. At Folio Title, we ask our buyer clients to confirm their vesting choice as early as possible in the purchase and sale process and at least 15 days before closing. Why? Because changing the way you hold title at the last minute can delay the closing, including for the lender who is preparing the mortgage and loan documents. What about closing and changing the way you hold title after closing? It's certainly possible, but changing the way you hold title after you've closed can lead to additional costs and taxes and has important legal consequences, especially when obtaining a mortgage to purchase the property. So even though many will tell you just close and change it after the closing, you really don't want to pay extra fees and taxes, and you don't want to risk the mortgage for something that can easily be taken care of before closing with the proper planning. So choosing vesting is a strategic decision. There's no one size fits all because it depends on your family, your risks, and your future goals. As your title Sherpa, our goal is to make sure you understand the terrain before you choose your path, and then guiding you through the journey of buying and selling real estate. While we help you learn about these important topics in our channels, we always recommend a conversation with an attorney or CPA to make sure your choice fits with your specific needs. If you're buying property in Florida and want a journey that is transparent and surprise-free, Folio Title is ready to lead the way. If this guide helped you, please like and subscribe and share it with someone who's going to start their home buying journey. I'm Ricardo Teran, your Title Sherpa. I'll see you at the summit.